Hi there, I'm Taylor Kaufman.
And I'm Alejandra Moreno.
And this is the Wake Podcast. So last week we were talking about what happens when a minor receives an inheritance, which is what happens when a guardianship is open, which is totally avoidable. And this week we're going to talk about what happens when a guardianship is not avoidable. So what the situation looks like.
Right. So when a guardianship receives an inheritance from a probate case, yes, if the deceased person had planned properly, that, part of the process could have been avoided. When a minor is injured and there is a civil lawsuit filed against a person or a building, a company, and they receive a settlement. You've mentioned in the past, somebody who's under 18 doesn't have the capacity to sign legal documents. They don't have the capacity to receive an inheritance or a settlement. So those funds do have to go into a guardianship. And usually it is not avoidable.
Right.
It's just the nature of the beast. So those funds, like we spoke prior, are going to have to sit in a guardianship case until the minor turns 18. Now, the court has a few safeguards when it comes to settlements. So once the guardianship case is open, the court will appoint a guardian ad litem. And this is an attorney that will review the settlement to make sure that the minor is receiving the best settlement. Sometimes a settlement statement, right? All of the payments that are going to come out of the settlement, sometimes it has a lien or maybe an insurance payment or something that the guardian ad litem can research and say, wait a second, that should be paid out of their insurance or that should be paid to make sure that the minor is receiving the maximum amount.
Right.
And once that guardian ad litem files the report, then the settlement is approved and those funds now come into the guardianship. And we talked a little bit about investments, right? What you can do with those funds to help it grow while the minor is, still a minor and is sitting in a guardianship. But as we mentioned, it really depends. It depends on the judge. It depends on the amount of the settlement. It depends on the family and their needs. And it depends on so many factors that it's very risky.
Definitely.
Right? Sometimes the money just sits there and we just have to wait. But something that we didn't talk about was the annual requirements for a guardianship.
Yes.
So usually the funds are just going to sit there until the child turns 18 unless the guardian wants us to ask the court for money. But technically the requirements for a guardianship case to keep it active is going to be the annual accounting. Right. And you worked on a few of those.
Yes.
So why don't you talk a little bit about what that looks like and what we have to submit to the court?
Right. So an annual accounting is basically a breakdown of all the money that's gone into the account, all the money that's come out of the account. So including any interest that's been accruing in the account. It's a detailed accounting, like I said, of everything coming in and out, but so detailed, like any little charge, anything that comes out, we have to mark it on the accounting. And it's basically the judge wants to see everything, any transaction coming in and out of the account. So
and anything coming out of the account has to have a corresponding court order. Right. Because this is a blocked account, so money can't come out of it. So the accounting is going to list, at the beginning of the year, the first of the year, this is how much money was in the account. This is how much interest came in. Maybe there was a second settlement. Maybe the minor received money from somewhere else. All of that has come in. And anything that came out, the court order dated, whatever, authorized distribution of whatever it is, $500, that all has to be on the accounting.
Yes.
Bank statements have to be attached to the accounting, and the accounting has to be approved by the court auditors in order for us to be in compliance and see the next year, right?
Yeah, of course, yeah. And it could be a lengthy process depending on how many, how many distributions were taken out of the account, and it's required.
If it's an investment account, if there are other
exactly.
assets, absolutely. And in guardianship cases where the guardian is not the natural parent, we also have to do an annual plan with a physician's report. So we have a few cases, guardianship cases, where the guardian is a grandparent. And even though the kid is living with the grandparent's taking care of them, every year we have to notify the court where the kid lives, who they live with, if they have any insurance, if they have any disabilities. And every year that grandparent has to take the kid to the doctor. The doctor has to fill out the physician's report, and that has to be submitted to the court as well.
Yeah.
which is kind of, extra legwork. And that's something we see in guardianships of adults. But if the guardian is not the parent, we have to do that for the minor as well.
Yeah, along with the accounting. And there's deadlines for these, documents as well. So
yes,
we're working on a deadline, and a lot of times it's hard for the parent or the guardian to coordinate these doctor's appointments
and get them in on time. Yeah, absolutely. And the guardian has to go through, especially at the beginning of the case, some legwork, right? When we have a guardian come in, first they have to do their fingerprints before they're appointed, and a background check. Now a lot of counties are requiring a credit report.
Yes.
And so far we haven't seen anybody disqualified because of their credit report, but that might be in the works.
Yeah.
And once they're appointed, in most counties, the guardian has to take a guardianship course.
Guardianship course, yeah.
To tell the court that they have, the knowledge of how the guardianship works, and it's time consuming.
Yeah,
it's a lot of time.
4 or 8 hours, depending on what kind of guardianship is open. So guardianships are very time consuming and could be frustrating sometimes because you don't have access to those funds. But I think the main point is that guardianships can be avoidable, right? So if you're receiving an inheritance with a proper estate planning, you can avoid a guardianship.
Yes.
Now, if you're receiving a settlement, that's a different story like we spoke about, but there are some ways to avoid a guardianship.
We have had a few cases where there was a settlement where the minor was already disabled and they're already on Medicaid. And the attorney that filed the personal injury case is able to get a guardian ad litem appointed in the civil case. And if the guardian ad litem puts in their report, no guardianship, let's put all this money into a special needs trust, right? So very, very briefly, a special needs trust is a special type of trust that can hold assets without disqualifying somebody from government benefits, Medicaid, disability. But that is a whole other podcast, right? That's pretty complex. But we have had cases where the personal injury attorney has a guardian ad litem that recommends no guardianship. Let's just put the funds into a special needs trust. And, but those cases are very few and far between.
Yeah.
I'd say usually when we're seeing a settlement go to a minor, usually you're looking at a guardianship and the money's going to be in there until the minor turns 18 for sure.
But I have to say, that's what makes our job so unique. We do probate, estate planning, and guardianship, so we know what tools we can, present to the court to kind of maybe avoid a guardianship or to lessen the time of a guardianship. So I just want to point that out.
Absolutely. And having a good relationship with the personal injury attorney, right, or the medical malpractice attorney, and making sure that the client has their case handled by somebody who knows how that works. And, a lot of times, since we have relationships with these attorneys, we try to push for no guardianship. It's against our interest, right? We can't charge for the guardianship. We don't have this case for years and years. But we know the struggles of being in the guardianship court. We know the struggles of a parent that has that money locked up, or a child that needs that money. So we do try to work with the civil attorney to find ways around it. Sometimes it's just not going to happen. There is no way around it. It has to go into a guardianship.
Yeah.
But if we can, we're happy to help and happy to recommend special needs planning if it's an option to keep it out of guardianship. But make sure if it's a already disabled minor, to make sure those funds are protected. They can still use those funds, but we protect their government benefits because a lot of these kids are going to be disabled their whole life. So losing Medicaid, no matter what the settlement is, losing their Medicaid and the services, they receive, that's like a huge issue.
Yeah, it is.
So definitely a minor beneficiary in an estate, that is avoidable. Settlement going to a minor beneficiary, usually not avoidable. There are a few instances where we've seen it, we've been able to avoid it, but usually it's not avoidable. Right. But if it is avoidable, the best thing you can do is talk to an estate planning attorney who knows what they're doing, and you try your best to keep it out of the courts.
Yes, of course.
So thanks for joining us today on the Wake podcast from ASM Law Group, preserving what matters most for those who matter most. The Wake is for informational purposes only and does not constitute legal advice. The discussions in this podcast are meant to bring awareness to important issues, but they should not be considered a substitute for professional legal guidance. If you need legal advice tailored to your specific situation, please consult a qualified attorney.